Assalamualaikum and hi. Today our group will discuss the rule that the beneficiaries must not have any nexus to the settlor in charitable trust.
These are our group members.
My name is Siti Arisya binti Muizuddin and my matric number is 055286. So what is charitable trust and personal nexus rule? Charitable trust is a public trust. They do not have beneficiaries like other express trusts. Instead, trust property is established for the benefits of the general public or a subset of the general public. Moving on to the personal nexus rule, the test is to show that the trust was established solely for the benefits of the general public or a subset of the general public with no nexus to blood or appointment.
Hello and a very good day. My name is RUBINISWARY, daughter of AMUTHAN, metric number 054940. I'm going to explain regarding the requirements under the personal nexus test. It should be for the public benefit, which is the benefit that is provided to the entire public or significant part of it. For the trust to be a valid charitable trust, there must be no nexus between the donor and the beneficiaries. Charitable trust can be created for educational purposes, advancement of religion, or any other purposes that benefits the public, such as sports. However, there is an exception for the personal nexus rule, which is under the cases of poverty. Under the cases of poverty, the trust is still considered valid even though there is a nexus between the donor and beneficiaries.
Hello, my name is IZZATI AZURIN binti Muhammad RUSDI and my matrix number is 055118. The case of Oppenham against Tobacco Securities Trust Company Limited. This case highlights on the second requirement, which is no nexus between the donor and beneficiary. This case ruled that even though the group of persons may be numerous, if the nexus between them is their personal relationship to a single propositus or to several propositi, they are neither the community nor a section of the community for charitable purposes. Where the beneficiaries are defined by reference to a personal nexus, the trust, as a matter of law, cannot be charitable.
Firstly, public benefit in terms of religion. What does it mean to promote religion for the public benefit? Religion must be promoted in order to be charitable. To advance a religion implies to promote, preserve or practice it, as well as to enhance belief in the supreme person or thing that is the religion's object or emphasis. This can be seen in the case of Peguam Negara Malaysia and Ching Chi Kor as Secretary of Persatuan Kebajikan dan Amal Liam Hut Tong Chor Seng Tuan, where the fact mentioned that a testator bequeathed properties and money in 1941 to build and maintain a pagoda so that members of a Buddhist organization might carry out their activities. The pagoda was never erected and the funds left behind will be spent. The lands were declared a public charity trust by the High Court in 1982. Following that, the group planned to raise public funding to construct the pagoda. The issue is that whether High Court have right to grant respondent to be made trustee of public charitable trust. The court held that we were of the opinion that this was not a frivolous and vexatious application and that it merited further argument at the substantive motion after examining the parties' written and oral arguments. We were convinced that the construction of a pagoda for religious activities and purposes for Buddhists was a matter of public concern.
Next, public benefit in terms of educational purposes. Generally, it is a charitable trust even if for private school as long as it does not run for private profit. Example of case under education is Independent Schools Council against Charity Commission for England and Wales. In this case, the Independent Schools Council (ISC) applied to be registered as a charitable trust. This application was on the ground that they help in the advancements of education. In addition, the ISC also sought a court order that would have the effect of quashing certain parts of the guidance. In that guidance, it stated that where the benefit was to a section of the public, the opportunity to benefit should not be restricted by ability to pay fees. In simpler words, in this case, The fees is considered as one of the restrictions since not everyone is able to pay it. Thus, it does not fit the guidance which express that in order for the public to be truly benefited, the opportunity should not be restricted, in essence, by ability to pay fees. The main issues from this case is that the court need to determine whether ISC was fit to be registered as a charitable trust. In this case, the court held that the public benefit should be directed and available for a sufficiently large section of community when the poor are being excluded from joining any organization and benefited from the opportunity. Thus, the organization could not be considered charitable.
Charitable trusts can also be created for poverty. The case is Charity Commission for England and Wales and others versus Her Majesty's Attorney General. The issue is whether the poor relation charities, company employee charities and membership charities are capable of being charitable trusts and whether they satisfy the public benefit test. The court in this case held that poor relations charities, company employee charities and membership charities were all capable of being charitable. The upper tribunal has confirmed in its decision that trusts for the relief of poverty among a restricted pool of beneficiaries defined by a relationship to an individual or an employer or membership of an unincorporated association can satisfy the public benefit test and are capable of being charitable. Next, the trust can also be created for other purposes such as recreational purposes. The case is Guile versus IRC. The issue in this case was whether the recreational facilities open to the public could be valid charities. The House of Lords in this case held that the recreational facilities can be considered as charitable trusts as they are provided for the benefit of the public. Here it is proven that trusts created for recreational purposes can also be considered as charitable provided that there is no nexus between the donor and also the beneficiaries.
In conclusion, in cases where there is personal nexus between donor and beneficiary, the trust is considered as non-charitable trust except for the case of poverty.